Imagine a courtroom. The air is thick with tension, and the fate of a person or a company hangs in the balance. Crucial to these moments is often the voice of an expert, a specialist called upon to shed light on complex matters that lay people, including judges and juries, might not understand. But how do we decide if this expert, with all their impressive credentials, is truly believable? What makes their words carry weight? Welcome. Today, we're going to explore a fascinating and critically important aspect of our legal system: expert witness credibility. This isn't just about who has the most degrees or the longest resume. It's a deep dive into how trustworthiness is perceived, established, and sometimes, unfortunately, undermined. It's a topic that blends legal frameworks, human psychology, and ongoing debates, all of which profoundly influence the outcomes of cases every single day. The role of an expert witness is to help the court understand evidence or determine a fact and issue by applying their specialized knowledge. Think of a medical doctor explaining a complex diagnosis, an engineer analyzing a bridge collapse, or a forensic scientist interpreting DNA evidence. Their testimony can be the linchpin of a case, turning the tide with their specialized insight. Because their influence is so significant, understanding what makes them credible is not just academic, it's fundamental to justice. This isn't a new or fleeting concern. It's a topic that legal and scientific communities continuously grapple with, striving for greater objectivity and fairness. So let's break down what truly makes an expert believable. Research points to several core areas that judges and juries consider. Firstly, and perhaps most obviously, are the qualifications. This isn't just a piece of paper. It's a comprehensive look at their education, their specific relevant experience, their professional credentials, any publications they might have, leadership roles, and their history of teaching or lecturing in their field. These elements build a foundational layer of authority. But it goes beyond the resume. It's also about their familiarity with the specific case at hand. An expert might be brilliant, but if they haven't thoroughly reviewed the evidence and facts pertinent to this particular situation, their testimony can feel less grounded. Equally important are the factual basis for their testimony, meaning what evidence are they using, and the reliability of their methodology. How did they arrive at their conclusions? Is their approach scientifically sound and generally accepted within their professional community? Beyond these concrete elements, there's the human factor, the expert's demeanor in court. This includes how confident they appear, their perceived honesty and integrity, their sincerity, whether they are respectful to everyone, and even subtle nonverbal cues. Perhaps most crucially for a lay audience, it's their ability to clearly translate complex information into understandable terms, without oversimplifying or condescending. An expert who can connect with the jury, making dense scientific concepts accessible, often holds a significant advantage. Now, let's talk about the legal gatekeepers. To ensure that only reliable and relevant expert testimony reaches the ears of judges and juries, legal systems have established standards for admissibility. The most prominent of these in the U.S. federal courts and many state courts is the Daubert standard. Established by a Supreme Court case in 1993, Daubert v. Merrill Dow Pharmaceuticals, it mandates that judges act as gatekeepers.
In contrast, some state courts still adhere to the older Frye standard from a 1923 case. This standard is simpler, focusing solely on whether the expert's methodology has general acceptance within its particular scientific community. The existence of these two different standards across jurisdictions is actually a persistent point of debate, with legal scholars continually discussing which approach best ensures reliable evidence and promotes uniformity. Beyond the legal rules, we can't ignore the psychology of persuasion. Jurors are human, and their perceptions are influenced by more than just the facts. Personal experiences and attitudes can shape how they interpret testimony. An expert's confidence, their perceived trustworthiness, and even their likability can sway opinions, sometimes independently of the purely factual content. This leads to a critical debate. Are juries truly understanding the complex scientific or technical testimony, or are they more swayed by the expert's presentation style? The challenge, then, is to ensure accurate information conveyance without scientific rigor. This brings us to a significant and often contentious issue: bias. Perceived neutrality is absolutely critical. Research extensively explores issues like the hired gun effect. This is the perception that an expert's opinion might be influenced by the party who retained and compensated them, leading to skepticism among jurors. Furthermore, experts themselves, being human, may have unconscious biases that they don't even recognize, which can subtly or not so subtly influence their findings and testimony. To address these complexities, many different groups are involved. Academic researchers delve into the psychology of credibility and bias, developing models to measure how it's perceived. Legal and professional organizations like the American Bar Association, ABA, and the Forensic Expert Witness Association, FEWA, contribute to establishing guidelines and ethical standards. And then there are expert witness service firms that specialize in selecting, vetting, and training experts for legal professionals, highlighting the ongoing need for careful stewardship in this field. Despite all these efforts, several significant controversies and questions persist regarding expert witness credibility. The hired gun problem remains a major concern, fostering juror skepticism and emphasizing the need for robust cross-examination and judicial scrutiny. The continued existence of divergent admissibility standards like Daubert and Frye across different jurisdictions creates a lack of uniformity, making it challenging for legal professionals and sometimes leading to different outcomes based on geography rather than pure merit. We also continue to grapple with the core question of juror comprehension versus persuasion. When experts present highly technical information, how much do juries truly grasp, and how much are they influenced by personality or presentation? And what happens when opposing experts offer completely contradictory opinions? How are juries, often without scientific backgrounds, supposed to discern which testimony is more credible? This challenging task is typically left to juror discretion, which raises questions about the fairness of the outcome.
So, what does the future hold for expert witness credibility? It's a field characterized by continuous development and a persistent push for refinement. The ongoing academic research into the many factors influencing credibility and bias, coupled with the dedicated efforts of legal and professional organizations, like the ABA, to establish clear guidelines and ethical standards, points toward a future focused on enhancing the objectivity and reliability of expert testimony. The very existence of specialized expert witness service firms underscores a continuous need for better selection, more rigorous vetting, and more effective training processes for those who step into the courtroom. The persistent debates we've discussed today over admissibility standards, juror comprehension, and the hired gun problem suggest that efforts will continue to be directed towards improving our legal frameworks and developing more effective methods for presenting complex information to juries in a way that is both accurate and understandable. Ultimately, the goal is to strengthen the integrity and impact of expert witness contributions in court. This journey towards clearer, more trustworthy testimony is an ongoing one, vital for ensuring that justice is not just sought, but genuinely served. The credibility of an expert isn't a static concept. It's a dynamic interplay of qualifications, methodology, presentation, and ethics, constantly evolving as our legal and scientific understanding deepens. Thank you for joining me on this exploration.